This video is a little different from the others in this series. We've spent a lot of time talking about Medicare plans, premiums, and coverage decisions. This one is about something that has nothing to do with which plan you pick and everything to do with what happens when you can't speak for yourself. I'm going to talk about the legal documents every adult, especially as you approach 65, should have in place. Not because you're planning for the worst, but because having these documents done is one of the most loving things you can do for the people around you and for yourself. I'm Robin Dall, independent Medicare broker, Medicare educator, and Florida commissioned remote online notary. This is the part of my work that I think matters more than most people realize. Let's get into it. When you turn 65 and step into Medicare, you're making decisions about your healthcare coverage. But there's a parallel set of decisions that most people put off and shouldn't. What happens if you're in the hospital and can't communicate? Who makes medical decisions for you? Who would legally have the authority to access your accounts and pay your bills? Who knows what kind of care you do or don't want? Without the right legal documents, those decisions may end up in court, where a judge, not you, decides what happens next, and not necessarily the people you would have chosen. That process is called guardianship, sometimes referred to as conservatorship in other states, and it can be expensive, time-consuming, and deeply stressful for your family. The good news is that a small set of documents, done properly, puts you in control. And putting them in place now, while you're healthy and thinking clearly, is far easier than trying to navigate those decisions in the middle of a crisis. The first document is a durable power of attorney, often called a DPOA. This document designates someone, called your agent, to handle your financial and legal affairs on your behalf. And it continues to work if you become unable to manage things yourself. We're talking about paying bills, managing bank accounts, handling real estate, filing taxes, managing investments. The word durable is important. It means the document remains in effect even if you become incapacitated. A non-durable power of attorney typically ends if you become incapacitated, which is exactly when you'd need it most. Your agent doesn't have to be a lawyer or a financial professional. It just needs to be someone you trust completely to act in your best interest. Most people name a spouse, an adult child, or a close trusted friend. A few things to know. Your agent is required to act in your best interest, and certain actions, like making gifts or benefiting themselves, must be specifically authorized in the document. And you can set limits on what your agent can and cannot do. Without a DPOA, if you become incapacitated, your family may have to go to court to get the legal authority to manage your affairs. That process can take time, legal fees, and court involvement at the exact moment your family is already dealing with a crisis. The second document is your healthcare surrogate, sometimes called a healthcare proxy depending on your state. In Florida, this is called a designation of healthcare surrogate. This document is separate from your financial power of attorney. Where that one handles financial and legal matters, this one covers medical decisions. It designates someone to make healthcare decisions on your behalf if you're unable to make them yourself. Your healthcare surrogate can communicate with your doctors, review medical information, consent to or refuse treatment, and make decisions about your care based on what they know about your wishes and values. This is one of the most important decisions you'll make. The person you choose needs to be someone who can handle pressure, who understands what matters to you, and who will advocate for you, even when it's difficult. It does not have to be the same person as your financial power of attorney, though many people choose the same individual for simplicity. The third document is a living will, sometimes referred to as an advance directive. In Florida, a living will is a type of advance directive that specifically outlines your wishes about end-of-life care. This is where you put your own wishes in writing. What kind of medical treatment do you want if you're in an end-stage condition, a terminal condition, or a persistent vegetative state and unable to communicate? Do you want life-prolonging procedures to be continued? Under what circumstances? What about artificial nutrition or hydration? A living will helps take the burden of those decisions off your family. Without it, your loved ones may be left guessing and sometimes disagreeing about what you would have wanted. That can place an enormous emotional weight on people who are already dealing with a difficult situation. A living will does not have to be complicated or cover every possible scenario. It needs to clearly express your wishes and values in enough detail that your healthcare surrogate and your doctors can follow them. I would encourage anyone approaching 65 to take the time to think through these decisions, not just sign a form. What matters to you? What does quality of life mean to you? And have those conversations with the people who may be making decisions on your behalf, so they're not walking into those moments without guidance. Here's something people don't always think about. These documents are only as good as the way they're executed. In Florida, and in most states, a durable power of attorney, healthcare surrogate designation, and living will all have specific signing requirements that must be followed for them to be legally valid. That typically includes signing in the presence of witnesses and, in some cases, a notary. If the documents aren't executed properly, they may not be honored. A hospital may refuse to recognize a healthcare surrogate designation that wasn't witnessed correctly. A bank may reject a power of attorney that doesn't meet legal requirements. The whole point of having these documents is that they work when you need them, and that only happens if they're done correctly. This is where my role as a Florida commissioned remote online notary can help. I can notarize documents like durable powers of attorney for Florida residents remotely, so you don't have to drive anywhere or sit in a waiting room. We complete the process over a secure video call, and when done properly, those notarizations are legally valid. I want to say one more thing about timing, because this is where most people get tripped up. People know they need these documents. They intend to get them done. And then life gets busy, and they don't, until something happens. I've had clients come to me for Medicare help who shared that their spouse had a health event, and they didn't have a power of attorney in place. The scramble that followed was stressful, time-consuming, and often expensive. And in many cases, it could have been avoided. The best time to put these documents in place is when you don't need them, when you're healthy, thinking clearly, and not in the middle of a crisis. That's where most of you are right now. You don't necessarily need an attorney to create basic versions of these documents, though working with an estate planning attorney is a smart decision for more complex situations or if you want more customized planning. There are reputable resources available to help you get started. But whatever you do, don't put it off. So those are the 3 documents every person, especially as you approach 65, should have in place: a durable power of attorney, a healthcare surrogate designation, and a living will. Done properly with the correct witnesses and, where required, notarized. This is the last video in the Core Medicare series. I hope the series has helped you feel more prepared and a little less overwhelmed. Medicare is complicated, but it doesn't have to be confusing when it's explained in plain English. If you have questions about your Medicare coverage or your plan options, or if you need help properly executing and notarizing documents like a durable power of attorney, I'm here. Head to RobinsWisdom.com to request a free Medicare review or learn more about remote online notary services. No call centers, no 1-800 numbers. Just Robin Dall, Medicare educator and Florida commissioned remote online notary. Here to make this next chapter feel a lot more clear and a lot less overwhelming. Thank you for watching. I'll see you out there.